Personal representatives should complete the seller's property disclosure statement, SPDS, even if they have never resided in the property facts. Acting on behalf of an estate, the court-appointed personal representative listed the property for sale shortly after the death of the owner. The personal representative has never resided in the property and has virtually no knowledge of the property's conditions. The personal representative ultimately entered into an Arizona Realtor Czar residential resale real estate purchase contract with the buyer. The buyer has now requested a SPDS, and the personal representative does not want to provide it, claiming she has no knowledge of the property condition. Issue: is the personal representative required to provide a SPDS even though she has virtually no knowledge of property condition? Answer: see discussion. Discussion. Although some sellers are reluctant to provide a SPDS because they lack knowledge, a seller of real property that knows of facts materially affecting the value of the property that are not readily observable and are not known to the buyer must disclose those facts to the buyer. Hill v. Jones, 151 Ares 81, 725 P2, 1115, Appendix 1986. Additionally, by entering into the purchase contract, the seller agreed to provide a SPDS within 3 days of its acceptance. See Section 4A. The personal representative is therefore contractually obligated to provide the SPDS to the buyer, even though she has virtually no knowledge of the property condition. No requirement to disclose ghosts after close of escrow issue. 2 months after close of escrow, the seller calls the listing broker to tell the listing broker that the seller had ghosts in the home named Angel and Charlie. Does the listing broker now have to disclose the occupancy of these ghosts to the buyer of the home? Answer: probably not. The general rule is that after the close of escrow, the agent has no obligations of disclosure to a buyer or seller in the closed transaction, except to keep confidential any information learned during the agency relationship. Therefore, the agent probably has no obligation to disclose the presence of ghosts to the buyer 2 months after the close of escrow. Note: ARS. Par 32-2156 protects real estate licensees and the seller from failing to disclose during the transaction certain material facts relating to the home, such as suicides, murders, or other felonies, and registered sex offenders in the vicinity of the home. The presence of ghosts in the home, similar to the ghosts in the movie The Amityville Horror, could be a material fact that a reasonable buyer would want to know. If a material fact, ARS, paragraph 32-2156, would not protect the seller and real estate licensees from failure to disclose these ghosts. Arizona Realtor Magazine. Disclosure. August 2009. No obligation to disclose burglary during escrow issue. During the escrow period, the seller's home is burglarized. The seller lost valuable personal property, such as jewelry, clothing, and artwork. There was no damage to the home. Does the seller or the listing broker have to disclose this burglary? Answer: no. Under ARS, paragraph 32-2156A, 1. The seller and any broker in the transaction have no liability for failing to disclose that a felony has occurred in the home. Burglary of a home is a Class 3 felony. ARS, paragraph 13-1507B. Therefore, there is no requirement of disclosure. No Arizona law requiring seller to provide SPDS to the buyer issue. The seller is an investor who does not want to provide an SPDS to the buyer and is demanding that Section 4A of the contract requiring a SPDS be deleted. Does Arizona law require a seller to deliver an SPDS to the buyer of a home? Answer: no. Under common law disclosure principles, a seller of real property must disclose to a buyer any material, adverse fact affecting the value of the real property. Unlike some states, in Arizona, a formal SPDS is not required by statute. Note: the seller's SPDS, however, is valuable for disclosure of more than just the material, adverse facts, e.g., the identities of utility providers and any transferable termite warranty. Nearby nudist colony is a material fact that should be disclosed. Facts: the agent listed the property for sale. When visiting the property to meet the septic inspector, the agent noticed a nudist colony about 400 yards away. The agent asked the seller for details. The seller confirmed that there was in fact an active nudist colony down the street. The seller insisted, however, that because the nudist colony was not on the property itself, no disclosure was required. Issue: is the listing agent obligated to disclose the nearby nudist colony? Answer: yes. Discussion: the listing agent has an obligation to disclose all known facts which materially or adversely affects the consideration to be paid. AAC R4 28 1101B. Because the nearby nudist colony will likely affect the price a buyer is willing to pay, the listing agent is obligated to make the disclosure, even though the nudist colony is not actually operated on the property. Multiple short sale offers should be disclosed facts. An out-of-state investor seeks to purchase a single investment property in Arizona. Not knowing which transaction will prove successful, the investor submits offers on 4 different short sale properties, 3 of which are accepted. Issue: must the investor disclose to each seller the fact that he has entered into multiple contracts with the intent to buy only one? Answer: if the investor does not have the financial wherewithal to close on all 4 of the short sale offers, then his multiple offers should be disclosed. Note: the buyer's agent has a parallel duty of disclosure. See AAC R4 28 1101, Arizona Realtor R Magazine, August 2013. Disclosure.